I thought I might give you some introductory comments about disability discrimination laws and the way they work, and some of them will answer parts of, if not all, of some of the questions that you've already asked, and then I'm very happy to get involved in the dialogue, which Alyssa will facilitate. So we have a federal law, and we also have a state law in Queensland, which makes it unlawful to discriminate or treat a person less favourably, or discriminate against a person on the basis of their disability. There are other grounds as well, but I'm just talking about disability discrimination at the moment. And these laws apply in all areas of public life: employment, education, good services and facilities, clubs, accommodation, sport, etc., etc. So, the question, do discrimination laws apply to schools? Yes, they do. Do they apply to homeschooling and to support provided by government or private organisations in that way? Absolutely. And do they apply to other things like TAFE and other services provided to kids and young people with disability? Yes, they do, because they're areas of public life. Now, what the laws do is that they say it's unlawful to discriminate against a person with a disability. And for the purposes of education, there's some other examples in other areas, but for the purposes of education, there's only one, there's an extra provision in those laws, which says we're not just talking about discrimination on its face, so we're not just saying, well, it's unlawful to discriminate against a person with a disability, let's say, by refusing their attendance at school. That is unlawful, okay? But if the school says, sure, a kid with a disability can attend, but the only way to get into the school is up a set of 10 steps, that's unlawful too. So the law says that school and education authorities have to make what's called reasonable adjustment or reasonable accommodation for people with disabilities. So if your child has, is for instance on the spectrum or has a learning disability, the expectation of this law, because it's social change law, is that the school will make an adjustment to meet the needs of that child with a disability and will provide them with the extra support. There's a case up here in Queensland called Clark versus the state of Queensland, which went to the federal court, where a young guy, Jacob Clark, who was deaf, wanted to go to school, and he wanted to communicate using Auslan, because that was his first language, Australian Sign Language. And he actually had, through another part of government and with his parents' support, he had the Auslan interpreters arranged, and the cost of them was covered. But the school said, no, you have to learn to lip read, and you have to be educated in English, which was Jacob's second language. And he challenged that decision in the federal court and won that case. There's another case of a young woman now, Scarlett Finney in New South Wales, who wanted to attend the school in the bush. And in fact, some of you may be aware of the 20 Years, 20 Stories films that we made at the Human Rights Commission just last year for the 20th anniversary of the Disability Discrimination Act. If you're not, you can Google 20 Years, 20 Stories, but I'm sure Lee has been posting about them on your Facebook page. And that tells Jacob's story. It also tells Scarlett's story. And she was refused enrolment in a school because she has spina bifida. And the school said, we won't be able to meet her particular needs. And the federal court said, you are required to meet those needs. Now, while that case was going on, she'd actually chosen to go to a different school, and so she was awarded just under $40,000 damages had to be paid by the school for not meeting her needs. So the law provides that you have to reasonably accommodate. And sort of setting out this in more detail are the standards under the Disability Discrimination Act, the education standards, which are a set of principles which, if you like, guide the way that the law is applied in this area. I'm not going to go through those today because I'd rather talk about your specific examples, but they're there and they sort of underpin the law. There's only one exception to the discrimination law for kids with disabilities. And that is if to provide the accommodation or the adjustment would cause the education authority unjustifiable hardship. Now these are legal concepts and sometimes they're hard for us to get our heads around, but unjustifiable hardship means more than hardship because the law expects schools, private or public, homeschool or local schools, to undergo hardship in order to accommodate kids with disabilities. But what the law says is when that hardship becomes unjustifiable, then they have a defence. Now, when does it come unjustifiable? Where is that line? There's no bright, clear line drawn in the sand that you have to cross, because just like every kid is different, every circumstance is different. So saying we don't have the resources is not an argument that stacks up, unless the resources being expected are, quote, unjustifiable, unquote. Now, again, there's a whole lot of criteria in the law to interpret what that unjustifiable hardship means, and courts have done that. In general, it's more than just hardship. And when you're talking about hardship for particularly for a government school organisation, the Department of Education is a big organisation with millions of dollars in its budget. The Queensland government is a big organisation with millions of dollars in its budget. That unjustifiable hardship has to be at a significant cost. But it's not just about money. There are a whole range of factors which determine unjustifiable hardship. Now, sure, cost is one, but the impact on the school of having kids attend and having to employ extra support staff is another. But when you start assessing impact, what courts do is, of course, assess the positive benefits as well as the negative impacts. So one of the things in the Finney case, and I heard that when I was a hearing commissioner before it went to the federal court, one of the things that I took into account was how the school would benefit from having a diverse range of students, who, just like the rest of the community, had various disabilities. And so I weighed that against the unjustifiable hardship, as well as all the things that I had to weigh in favour of the unjustifiable hardship. How the parent community would benefit from involving families who have within them kids with disabilities, and how the community would benefit if kids with disabilities are appropriately educated. So that's what the law says. Now, the way the law works is it doesn't work like a parking law, where there are inspectors going around fining organisations who discriminate. Discrimination law doesn't work that way. I wish it did, but it doesn't. Across the board, whether it's disability, race, sex, pregnancy, sexual orientation, in order to apply the law, you have to lodge a complaint. And then those complaints go to the Human Rights Commission, which is the national organisation for which I work, or the Queensland Anti-Discrimination Commission, which is the state organisation, and the commissioner there is a guy called Kevin Cox, who actually also has a disability, interestingly, and he's a good friend of mine. You lodge a complaint, and the commissions investigate that complaint, and they attempt to resolve it by conciliation. So you sit down with a conciliator in a room, and the department or the school authority sits there with you, and you talk about what the resolution of the complaint will be. Now, I know, because I've done this myself, I've lodged complaints. I don't have the authority as commissioner to initiate complaints. I've done it as an individual, and I lodged my complaints, and this is another one of the stories on 20 Years, 20 Stories, because the railway system in Sydney had no announcements, so I didn't know where I was on the trains, and I won that case in the federal court. So I know from having lodged complaints where the power balance is. And let me tell you, it's not with the parents, it's with the schools. So what I want to talk about today is some of the strategies by which we'll never totally even up that power balance, it'll always be this way, but I want to talk about strategies which might make it here instead of here. And that's really why I'm here to talk with you today. So I've probably said more than I should have. I'm going to give the microphone back to Alyssa, and we can continue with the document.